Good afternoon, sir. Can you see and hear us?
I can indeed, thank you.
May we please call Kelly Tolhurst?
Yeah,
After me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Could you confirm your full name, please, Miss Tolhurst?
Yes, Kelly Jane Tolhurst.
As you know, my name is Emma Price, and I will be asking you questions on behalf of the inquiry. Thank you for coming to the inquiry to assist it in its work and for providing the statement which you have. You should have a hard copy of that statement on the desk in front of you. Do you have that?
I do.
It is dated the 19th of June 2024. If you could turn to page 73 of that, please.
Oh, yeah.
Do you have a copy with a visible signature?
I do, yes.
Is that your signature?
It is.
For the purposes of the transcript, the reference for Ms. Tolhurst's statement is WITN 109-30100. Ms. Tolhurst, your witness statement is now in evidence and will be published on the inquiry's website in due course. As such, I will not be asking you about every part of your statement, just certain specific issues which are addressed in it.
Okay.
I'd like to start, please, with an overview of your professional background and career in government to date. You explain in your statement that you, before taking up an elected role, ran a marine business for 17 years.
That's correct.
Training as a marine surveyor during this time.
Correct.
You were elected to Medway Council in 2011, representing the Rochester West Ward.
Correct.
You were elected as an MP in May 2015.
Yep, correct.
You served as Assistant Whip to the Treasury from the 9th of January 2018 to the 19th of July 2018.
Correct.
And following that, you served as Parliamentary Under-Secretary of State for the Department of Business, Energy and Industrial Strategy from the 19th of July 2018 to the 13th of February 2020, where you were responsible for small businesses, consumers and corporate responsibility.
Correct.
This was your first ministerial appointment?
Yes.
And was it in this role that you became involved in some of the matters which the inquiry is concerned with?
That's correct.
You went on to serve for a little over 6 months as Parliamentary Under-Secretary in the Department of Transport,
That's
followed by serving as Parliamentary Under-Secretary at the Ministry of Housing, Communities and Local Government between September 2020 and January 2021.
correct.
You were Deputy Chief Whip in the Commons from July 2020 to September 2022. You then served as Minister of State at the Department for Education for a short time, before serving from the backbenches until the recent election.
Correct.
Is it right that the only time you have had involvement in matters relevant to this inquiry was when you were Parliamentary Under-Secretary of State for the Department of Business, Energy and Industrial Strategy?
Yes, that's right.
Moving then, please, to the civil servants who assisted you when you were Parliamentary Under-Secretary at Bays. If I have understood your evidence in your statement correctly, there were, broadly speaking, 3 pools of civil servants who provided you with assistance on post office matters. First, private secretaries from the department's private office.
Yes.
Second, officials who were subject matter experts in particular policy areas, who, for the part of your role which related to the post office, worked for UK government investments.
Yes, correct.
And the third category from August 2018, when it was established, were officials from the post office policy team within Bays. Is that right?
That's right.
So far as your private secretaries were concerned, is it right that they dealt mainly with managing your diary, preparing paperwork for your ministerial box, and managing correspondence?
Correct.
In terms of the advice you received from officials, you addressed this at paragraph 12 of your statement. Could we have that on screen, please? It's page 4. And towards the bottom of page 4, please. And you say here at paragraph 12, the breadth of a minister's portfolio is such that they have to a greater or lesser extent, rely on the advice of officials and make decisions on the basis of it. Ministers expect the advice given to be competent, accurate and reliable, honestly given, and on the basis that objectivity has been applied in the analysis of the facts. Why was the application of objectivity in the analysis of the facts important?
In my view, when you're coming in as a minister as potentially an amateur in the space in which you're operating, for example, in this particular instance, I didn't have any particular experience within the post office or that kind of structure. So, for example, the objectivity would be important because obviously you would want to be given advice where you feel that they've weighed up both sides of things. So you would be confident in the fact that you were taking a decision or had information that was sound and also had been looked at from a number of different points of view. So I think when they're giving you that advice, it's important that you have that range of the objectivity so that you can make decent judgments based on what's put in front of you.
Turning then to the information you were given about the post office in the early period when you took up your role as Parliamentary Under-Secretary at Bays, you explain at paragraph 9 of your statement that you had a broad policy portfolio covering a range of sectors. And it was such a busy portfolio that it was in fact split in two after you left Bays, is that right?
That's correct, yeah.
So there was a lot to get on top of.
Yeah.
You were given an entire portfolio briefing to start when you arrived in post. Is that right?
Yes, sorry, yeah.
And you also received a briefing on postal affairs specifically.
Yes. For the whole of the brief, it's quite common for new ministers to be given sort of a day one briefing on all the different elements that are included within the brief, because within the brief of a minister there may be things that you would have more sight of than others.
If we could have paragraph 13 of Ms Tolhurst's statement on screen, please. That's page 5. And in referring to that briefing on postal affairs specifically, you say in the last line, I was provided with some outline information regarding the Horizon IT system issues. At paragraph 14, is that your assessment of what you understood those issues to be at the time? Paragraph 14 there.
Yes, it was my assessment of what, the information that I had at the time, yes.
And you say, I understand at that time that a civil claim was being brought by a number of SPMs in relation to accounting losses suffered in branch as a result of the Horizon IT system, I understood that SPMs were alleging that there were widespread problems with the system and that Post Office Limited denied this. I knew that several SPMs had been convicted for accounting losses. You refer at paragraph 15 of your statement to briefing documents which you received on the 16th of August 2018.
Yeah.
Looking first, please, at how these briefing documents came to you, could we have on screen, please, UKGI 408342? And starting, please, with the original email dated the 10th of August 2018, which starts about 2/3 of the way down the page. This is from Stephen Clark, from the Post Office shareholder team at UK Government Investments. And going over the page, please. Mr. Clark says, please find attached. Actually, apologies, if we can just go back, please, to who this was sent to. This was from initially from Mr. Clark to the Permanent Secretary's private office, is that right?
Yes.
Going back over the page, please find attached an update submission with 5 annexes on the Post Office Horizon litigation case. This is an info sub to 1, bring Alex up to speed on the case. Was that Alex Chisholm, who was the Permanent Secretary?
Correct.
2, brief Alex on safeguards for handling Post Office Limited's legally privileged information under the disclosure protocol. And 3, focus on plans for the oral briefing on the 10th of September by Post Office Limited's legal counsel. Please note that Post Office Limited have password protected their background briefing, Annex 3, as an extra safeguard. The password will follow. For the benefit of copy addressees who saw this sub in draft a few weeks back, I should explain that the sub was put on hold while we collected the required signatures for recipients on the closed distribution list. And then there's a request not to share the submission beyond the closed distribution list. This email was then forwarded to your private office, going back to the first page, please, on the 16th of August 2018. So if we scroll to the top, we can see from Stephen Clark to, we can't see the full email address, but that is to your private office, isn't it?
Yes.
And just scrolling down a bit, please. It says, hi, Sam. Was Sam your private secretary?
Yes, she was. One of them.
One of them.
Yeah, one of them.
As discussed, here is the info submission that went to the PermSec on the Post Office Horizon litigation. I'm sending this now for information, as we won't be getting any comments back from Alex before the Minister goes away again. The recipients list in Annex 2 has been updated, and there's a reference to getting the new SPAD on board. We can see from the list of attachments with the update submission, just looking there under subject, the first attachment is the submission itself, and then we have 5 annexes listed. So it appears from this, doesn't it, that both the submission itself and all 5 annexes were sent to your private office on the 16th of August.
Yes, sorry.
The transcriber has to get your words.
Yes, so, apologies.
Thank you. It appears from your statement that you read the submission dated the 10th of August 2018, which was the first attachment to this email, because you refer at paragraph 23 to background information which you derived from the documents provided to you on the 16th of August, making specific reference to a paragraph of that submission. Is that right, that you read the submission itself at the time?
I believe I did read the submission at the time. Being a new minister, I had quite a lot to get through, and I would have read it because I did try and read everything that was put in front of me, which sometimes was a frustration to some.
Was this the first briefing that you had received specific to the group litigation since becoming Parliamentary Under-Secretary?
I believe so.
I'd like to explore, please, whether you read any of the annexes which were sent to you, which were discussed in the submission. If I can just stop you there. In your statement, it's not entirely clear which of the annexes you think you would have read at the time. So if we can just take that in stages. But forgive me, you wanted to say something.
No, apologies. I was sort of preempting what you were going to say. In relation to the annexes, I remember obviously reading the briefing. The protocol was something that I obviously remember obviously being put in front of me, because obviously it was subject to me being given further information. I don't remember what I was feeling at the time in August when I would have read those, and I may have read them sort of later than it might not have been on the 10th of August. It might have been sort of later on when the documents may have been shared with me.
Well, they were sent to your private office on the 16th of August.
Oh, sorry, 16th,
so I think
sorry,
it would have been after that date
Yeah.
if you did. But let's just take it in stages. If we can have on screen, please, paragraph 20 of Ms. Tolhurst's statement. That's page 7. So you say here, as to the other annexes, Annex 1 was the information sharing protocol, which you referred to just now, and Annex 2 was the onboarding protocol. I do recall receiving those documents at the time, but I do not remember reflecting on them. Did you read those 2 annexes?
I believe I did.
You would have been aware from those documents, and in fact from the submission, that Post Office Limited, BAYS and UKGI had by this time established a disclosure protocol which governed the flow of legally privileged and confidential information in respect of the Horizon litigation from Post Office Limited to UKGI and BAYS. Do you recall that?
Yes, I do recall that.
Could we have on screen, please, paragraph 17 of Ms. Tolhurst's statement? That's page 6. And you say this of Annex 3. At paragraph 8 of that submission, it is recorded that following the agreement of the protocol, Post Office Limited's legal counsel provided an initial background briefing on the litigation, Annex 3, including their KC's view on the merits of the case. And you say here, I did not receive this Annex 3 at the time and have not seen it since. Just to clarify, Annex 3 was sent to your office under cover of the email of the 16th of August. We've seen that from the email, albeit that it appears in the original email sent, it was password protected. Can you help with why you say here that you did not receive it?
Well, I don't remember receiving it. and I hadn't seen it, well, as I said in the statement, but I don't remember being given the QC's views on the merits of the case. So that's all I can sort of, genuinely sort of, with what I can remember from the time and sort of looking back now.
Looking, please, to the 10th of August submission itself, could we have that on screen, please? The reference is UKGI 18266. And we can see there at the top the date and the submission title, Post Office Limited, Horizon Litigation Update. Towards the bottom of page 2, please, there is a heading, Litigation Background Briefing and Updates. And paragraph 8 underneath that contains this. Following the agreement of the protocol, Post Office Limited's legal counsel provided an initial background briefing on the litigation, Annex 3, including their case QC's view on the merits of the case, and has since provided a further update, Annex 4, following discussion of the case at Post Office Limited's last board meeting on the 31st of July. For ease of reference, in Annex 4, UKGI has highlighted in yellow any information that is new and worthy of note. So this was in the submission itself, flagging the existence of both Annex 3, which contained the QC's view on the merits, and a further update from Post Office Limited's legal counsel at Annex 4, with anything that was new and worthy of note highlighted. Did you ask to see either of those documents when you read this submission?
So I generally don't remember. All I would say is that at the time it would have been over the recess period. I don't remember specifically asking for that, so I would be wrong to say anything else other than that, really. But it would have been a period where I wasn't necessarily in the department, so I may have been in the constituency, so it might have been something that I maybe didn't request.
Looking, please, to paragraph 11 of the submission, a little further down the page. This explains the purpose of the oral briefing from Post Office Limited's legal counsel, which was scheduled and which you were going to be attending for the 10th of September. Is it right that you think this in fact occurred on the 17th of October?
Yes, I believe it did. I've sort of checked my diary, and I actually had, another what they call a statutory instrument debate at the time that it was originally proposed. So I think that may have been the reason why it didn't take place.
And this is the explanation given of the meeting. The briefing is confirmed in your diary and the Minister's diary for the 10th of September. A proposed agenda and list of attendees drawn up between UKGI and Post Office Limited is attached at Annex 5. Post Office Limited's legal counsel Jane MacLeod, Chair Tim Parker, and CEO Paula Venables via telephone and video link will brief you on the key issues at stake, as well as on the financial, reputational and operational implications, which could be considerable, of an adverse ruling at November's Common Issues trial and or at the Horizon trial in March 2019, and Post Office Limited's contingency plans for dealing with these risks. This will be an excellent opportunity for you and the Minister to exercise shareholder scrutiny and seek reassurance on any issues of concern. So this was flagging up, was it not, that there were financial, reputational and operational implications potentially considerable ones, if there were adverse findings for Post Office Limited at either Common Issues or the Horizon Issues trials,
Yes.
and that contingency plans for dealing with these risks were in train.
Yes.
It was also flagging what was expected of the Permanent Secretary and you at the meeting, which was an exercise of shareholder scrutiny, as well as it being an opportunity to seek reassurance on issues of concern. When you read this, did it make you think to ask for Annex 3 or Annex 4, the QC's views and the new and noteworthy information?
Genuinely, I can't say if it did or not at that particular time. So I can't honestly tell you whether or not what I thought about in relation to those annexes you've outlined.
Could we have on screen, please, paragraph 24 of Ms. Tolhurst's statement? That's page 8. Your comments in this paragraph are made in the context of the documents sent to your office on the 16th of August, including the submission itself. And in the first half of the paragraph, you say this: I do not recall any advice being given at the time regarding the risks of the litigation. I was not given the impression that Post Office Limited were anxious about the litigation or that there was any particular risk involved with the litigation over and above the inherent risk associated with any legal dispute. Can you help, please, with why you took from the submission, and paragraph 11 in particular, that there was no particular risk involved in the litigation over and above the inherent risk of any legal dispute?
Well, in relation to, I'm just looking at, ultimately, I think at that particular time, or the informal or the briefing that I'd been given sort of didn't suggest at that particular time that there was any thing particularly that I should be aware of, or that would mean that there would be sort of more well, as big as it obviously what we now know, the risks and the troubles relating to the litigation. So I hadn't been given the impression, new into the post, that there was anything particularly to worry about. Obviously that was my understanding sort of going into that meeting. At the time, I suppose I was more concerned with actually any kind of litigation, what that would mean for the Post Office, what it would mean for the government. But that was sort of the limits of my sort of thinking at that time.
You say in the paragraph above, paragraph 23, that the only background information you derived from the documents was that the independent investigations by Second Sight found no evidence of flaws in the Horizon IT system, and that is taken from paragraph 12 of the submission itself. Given that this was background information which you derived from the documents at the time, did you ask to see Second Sight's report?
No, I didn't ask to see Second Sight's report.
At paragraph 25 of your statement, you say that it was obvious, notwithstanding your comments at paragraph 24 about what you appreciated in terms of risk, that the litigation was going to be an important part of the Postal Affairs brief. And you say that you did not think that the information provided in August 2018 had given you the information necessary to provide effective leadership from within Bays in respect of the litigation. You go on at paragraph 26 to say that you are someone who is interested in the detail and concerned to have all of the relevant information before taking a decision. And over again, please, at 27, you say this: "For that reason, I requested further information, and I was provided with the short further document entitled Briefing for Kelly Tolhurst MP, Postmaster Litigation. The document itself is undated. I do not recall exactly when I received it, but I'm sure it was provided after the 16th of August 2018 and before the meeting with Post Office Limited took place on the 17th of October 2018. It is a top-level summary document drafted by UKGI. I return to it below. That document was a one-page high-level briefing, as you say, but you were provided with two further briefings between August 2018 and the meeting which was discussed in the August submission, that of the 17th of October 2018. The first of these was a briefing ahead of a meeting you had with Paula Venables on the 3rd of September 2018. And you address that briefing at paragraph 28 of your statement. And you quote the section which raises concerns, there were concerns which were raised by UKGI that Post Office Limited had not done enough to prepare for potential business, reputational and financial implications of losing the litigation. Do you recall discussing this with Paula Venables at your meeting with her?
I remember, obviously I remember meeting with Paula Venables. I remember touching on it, but I would say that it was a touching on the litigation. It was very much an intro meeting. And obviously one of the things that there were other sort of postal or post office issues that were relevant as well. And my interest was obviously, as a minister, how could I affect and be helpful to the post office in relation to some of those other duties and responsibilities. So I do remember speaking with her. I remember the meeting, but I remembered it only being sort of touched on as opposed to gone into any great depth at that particular time.
And indeed, in your statement, you indicate that only 5 minutes of the meeting was allocated to the litigation as opposed to those other issues. Is that right?
Yes, approximately.
But this was, again, flagging up that there were business, reputational and financial implications of losing the litigation, this briefing ahead of your Paula Venables meeting, wasn't it?
Yes.
At paragraph 29 of your statement, starting 5 lines down, you say this: "I note Mr. Aldred recorded that Miss Venables had passed on the advice of Post Office Limited's leading counsel, that in summary, Post Office Limited will likely lose on some contract clauses, but not on the highest impact ones. Whilst I do not now recall the detail of the point made, that fits with my understanding at the time. I remember having the general impression that the Post Office Limited had confidence in its overall defence to the claim." There are 2 parts of the note of the meeting with Paula Venables on which you comment in your statement at paragraphs 30 and 31. And at paragraph 30, you say this: "I do agree with Mr. Aldred's note that I emphasised the need to provide plenty of detail, and Paula Venables said Post Office Limited would be in a much better position to do so after further briefings from their QCs and hopefully more information on the claims. This fits with my memory of dealings with Post Office Limited during my time at Bays. Post Office Limited always seemed willing to answer questions when asked, but I did find that they were sometimes difficult about what information they would volunteer. There was never a refusal to provide information if it was requested, but I did feel that details were not always forthcoming in a proactive way. Even at this early stage, your first meeting with Paula Venables, was this the impression you formed, or did that impression come later?
I think the impression would have come later. As I said in my statement, I was new to the brief. I wanted to understand as much as I possibly could. It would be usual for me to ask for further information or as much detail as I could. So it would have been normal for me to have said to Paula, provide me with as much information as possible. But as I sort of said in the statement, there was never I never ever detected any sort of resistance to giving me that information directly from Post Office. But obviously I felt, and when I reflect back, looking at obviously the documents and reflect back on that time, I did feel that I was asking for information all the time, or wanting further information. So obviously that's what's sort of formulated my view on this.
Was this an impression you formed when you were Parliamentary Under-Secretary at Bays, or is this one you have formed on reflection?
No, it was what was happening when I was actually within the department. But obviously at this particular time, so that meeting with Paula was on the 3rd of September. I had only just recently been appointed, and at that particular time, there were a number of just to sort of set the context, there were a number of big areas within my portfolio at Bays that required me to sort of get up to speed on pretty quickly. So it was, and actually this was the sort of first intro meeting. So that's why I was pleased actually when she suggested that, sharing information wasn't going to be a problem, but obviously as time went on, it was me asking for that information.
At paragraph 31, you say this: I also note what Nick Parker writes in the first paragraph. Paula frequently confirmed that challenge from Her Majesty's government is good, but also asked that HMG ensures the positive developments in Post Office are made clear, and that HMG continues to stress the important role that Post Office plays in communities up and down the country. Reading this comment now, I do feel that Post Office Limited was more interested in the department challenging Post Office Limited for the appearance of challenge, rather than sincerely listening and changing course in response. I got the impression that Post Office Limited expected the department to be positive about Post Office Limited, regardless of the scrutiny that the minister or department wished to apply. Again, is this an impression you formed at this point in September 2018, or one which came later?
It came later, yeah.
As far as you are aware, was this approach and attitude from Post Office Limited ever challenged by Bays or raised with the Post Office Limited board members at the time?
Sorry, at the time of the 3rd of September.
At the time that you had that impression and you had that concern,
yeah.
Was that approach and attitude that you described there ever challenged by the department with Post Office board members?
So I don't know if it was challenged by anyone within the department. I know that I had expressed frustrations over that period, particularly on this point of not feeling that maybe I was getting the information that I needed or that should be coming my way. I can't say that it would be wrong for me to say that I directly challenged Post Office Limited on that particular point. But I think that my feelings and frustration of that was understood by the team at Bays and the UKGI members that I spoke to and interacted with.
In general, did you feel restricted in your ability to change this attitude or approach, or to ensure that Post Office Limited acted upon suggestions made by Bays?
I would say that, I'm generally somebody who would, if I have an opinion and I'm not happy with something, I would generally make that clear. I would, I would have thought that. I mean, I'm just sort of making, I'm just trying to think what I may have done, sort of looking at it now, rather than sort of giving you any solid, solid sort of factual or answer to what actually would have happened at the time. But I think that, it was understood that I was, I felt frustrated at that particular, after that period of time, by sort of the reactions and information that was coming through, or that sort of of appearance. So, yeah.
The second written briefing you received further to the August submission and ahead of the 17th of October 2018 meeting was the detailed paper you address at paragraph 35 of your statement. Going over the page to that, please. And again, please. And here you say, on the 11th of October 2018, I received a briefing authored by Post Office Limited for the 17th of October meeting. The briefing was extensive, although section 2 setting out the background to the litigation was relatively short. I did not understand this to be a meeting about litigation strategy or the merits of the claim. It was really just a meeting about what was happening in the litigation. Just picking up there on your understanding of the purpose of the 17th of October 2018 meeting, this was, you think, the adjourned meeting, which was addressed in the 10th of August submission. And in that submission, the meeting was described in paragraph 11, which we looked at, as an excellent opportunity for you and the Minister to exercise shareholder scrutiny and seek reassurance on any issues of concern. And it was also envisaged that there would be some scrutiny of Post Office Limited's contingency planning at the meeting, wasn't it? Because that was why you were briefed ahead of the Paula Venables meeting to request sight of the contingency plan in advance of the meeting. Do you recall that from the documents?
Yes, I do recall it from the documents.
Can you help, therefore, with why you viewed the meeting as really just a meeting about what was happening in the litigation?
Yes. So, again, this would have been the first sort of major meeting that I would have had around the litigation in relation to the Post Office. And it was an opportunity, and whilst the contingency plan was an element, this was an opportunity for them to brief me about what was happening with the litigation, and an opportunity for me to discuss and ask questions. So for me, I felt that it was very much about the whole litigation, not just about the contingency planning. And obviously, I had limited knowledge. I'd only had what I had read prior to that, or informal conversations. So it was an opportunity for me to meet with all of the people involved and ask questions and listen to what they had to say.
But you're not saying by it was just about what was happening in the litigation that you didn't have the opportunity to apply that shareholder scrutiny at that meeting, because that was the stated intention, wasn't it, in the submission from August?
Yeah, I mean, at that particular meeting, I was concerned about to have more information about the litigation. I remember being able to ask questions. I asked questions about I did ask questions of the merit. I asked questions about the liability, what it would mean, what the post office felt about the outcome or potential outcomes of the litigation. So I think from my perspective, I wanted to use the meeting as a better understanding of what the current state of play was. I was very much aware that this had been going on for a long period of time, and I wanted to be able to perform correctly as a minister as in the best way I could, and the only way I would, I believe, is to understand what's going on in the detail. So whilst contingency planning was a part of it, I think from my perspective, it was very important that it was an opportunity for me to ask questions.
Could we have on screen, please, POL 30-22976? This is the briefing paper for the 17th of October 2018 meeting. Starting, please, with page 2, we can see a table of contents, and there were sections listed as 1 to 7, the executive summary, background to the litigation, key issues at trial in November, operational improvements already underway, contingency planning, communication strategy, and settlement options. You've said in your statement that you were interested in the detail as a general rule. Did you read all of the sections of this briefing when it was provided to you?
Yes, I would have done ahead of that meeting.
Going to the executive summary over the page, please, at paragraph 1.2. Under the heading, "What is the case about?" It says the case represents the culmination of a series of campaigns by disaffected postmasters and others, including a number of MPs on both sides, who believe that Post Office wrongly attributed branch losses to those postmasters, and that as a result they suffered financial and reputational harm. A theme of these campaigns is that flaws in Horizon, the in-branch point-of-sale system, were the cause of these losses. Going over the page again, please, at 1.8, the number of claimants is identified there as the group of 561 claimants. And then going to page 6, please. This is the second section, the background to the litigation. And at 2.2, there is this. In 2012, a small number of mostly former postmasters, under the banner of Justice for Sub-Postmasters Alliance, and with support from some MPs led by then MP, now Lord James Arbuthnot, claimed Post Office's Horizon IT system had caused losses, shortfalls in physical cash against cash holdings recorded on Horizon, which they had had to make good. In some cases, they had been prosecuted for these losses, usually for false accounting, theft, or both, while in other cases they claimed that it led to their contracts with Post Office being terminated, causing them financial loss and other personal harm, including bankruptcy, divorce, and emotional distress, including suicide. So this briefing was informing you that sub-postmasters had alleged that the IT system had caused losses which they'd had to make good, yes?
Yes.
This had led to some people being prosecuted for false accounting, theft, or both.
Yes.
Others having their contracts terminated with the consequences we see there.
Yes.
And they had had support from some MPs led by Lord Arbuthnot.
Yes. Yes.
Did the nature of the allegations being described here cause you any alarm by their very nature?
Yes, of course. Anyone sort of being accused of breaking the law or doing something regarded as illegal and the consequences of that, of course. You know, and for me, absolutely, that's why, you know, I was keen to understand more about what had gone on and what the current situation was with the post office.
Did this paragraph cause you to ask yourself whether you needed to test what you were being told by the post office about its position on the allegations?
At this particular time, at this particular meeting, no. And the answer to that is, again, this was the first big meeting that I had had with the post office to talk about the litigation in any kind of detail. And I was just formulating my views. I didn't have any developed views really prior to taking on the role as a minister. So, you know, of course, it's reading it's really concerning. But it didn't sort of, that particular paragraph in that briefing didn't, you know, I didn't, as you say, I didn't make any further decisions based on that.
Did you understand when you read this briefing that it was the post office which had been doing the prosecuting?
Yes.
Did that aspect of it cause you any concern taken with the information here in paragraph 2.2?
Yes. Of course, any kind of private prosecution is of a concern when, and especially when it's being done by an organisation. This, I think, I think I mentioned further in my statement, but this is where I sort of asked the question about, you know, what the post office really, you know, what the situation was with regards to the litigation, because I did feel that this was a situation where you had a very large organisation taking private prosecutions against, you know, excuse the phrase, small businesses or individuals in some cases. And so for a large organisation to take that kind of action against, you know, relatively small players, excuse the expression, you know, they must have been pretty sure or confident in their position to move that forward. So obviously, you know, that's how I was feeling at the time, and obviously I was getting to know what was going on and developing my views and thoughts and trying to suck up as much information that was being given to me.
At paragraph 2.3, there was this: in response to these assertions, Post Office appointed independent forensic accountants Second Sight to perform a top-down examination of Horizon. Second Sight issued a report in July 2013, which concluded that there was no evidence of a system-wide (systemic) problems with the Horizon software, but identified some areas where Post Office could have done more to support individual postmasters. This was the second reference to Second Sight that you'd had. When you read this, did you ask to see Second Sight's report?
No, I didn't ask to see Second Sight's report.
And why not?
It wasn't at the time. I can't really give you an answer as to why I didn't ask to see their report. I was making a judgment on the advice that was in front of me. I would have expected that the briefing to have given me sort of factual and relatively, you know, truthful information, but I didn't ask to see that, and I would have taken what I was given here on face value.
Could we have on screen, please, paragraph 36 of Ms. Tolhurst's statement? That's page 12. You refer here to paragraph 2.3 of the briefing document, so that's the paragraph we've just looked at, referencing second site. And you say in the last sentence of the last two sentences, I remember being reassured by this. I understood no evidence of system-wide systemic problems to mean that there were no fundamental flaws in the system that could affect SPMs more widely, although there may have been one-off issues arising from user error or occasional bugs. Going back a page to paragraph 33, please. You say, my general impression at this point in time was that Post Office Limited did not consider there was a serious problem with the Horizon system, albeit there may have been occasional bugs or errors in the system affecting individual SPMs. I understood Post Office Limited thought there was a possibility that the court may find against them on various contractual points or in respect of those occasional bugs or errors, but did not think they would lose on anything significant. So the reference here to occasional bugs or errors in the system affecting individual SPMs, did you at the time question whether this system, which you understood to have bugs or errors affecting individual SPMs, even occasional ones, could be described as robust, the language which was being used by Post Office?
So at that particular meeting, the sort of terms, occasional bugs or errors, I'm not I'm not a technical expert, particularly with computers and computer systems. So I wouldn't have, I wouldn't have maybe have asked that question. But I think for me, it was very much about, I was sort of at that particular meeting give assurances that, the representatives themselves, the people in the room, were telling me that there was no systematic issue. It was played down in the sense that it was only very minor. So I, again, I took what I was told on face value at that early meeting, without sort of probing further what bugs or errors could potentially be. However, I'm not an expert in tech or computers, so even if I had have, I'm not sure what information they would have given me to maybe lead me to take different views or ask for something further, if that sort of makes sense.
Taking it fairly simply, did you understand these occasional bugs or errors to be material? That is, they were affecting SPMs in the way they claimed, causing accounting difficulties? Yes, I would say so. Did you question whether these occasional bugs or errors were visible to sub-postmasters when they occurred, or whether illusory losses caused by bugs could be told apart from genuine losses by the Post Office? So in relation to the bugs or errors in the system, I didn't ask and I didn't have information about those specific bugs or errors and potentially how they were affecting postmasters. I definitely was looking at it from more of a global level, more of a top level issue, rather than the individual specific points, which is that's an honest sort of position of what I was thinking at the time. Do you recognise now that absent bugs or errors being visible to SPMs or distinguishable from genuine losses, wrongful action might be taken against someone, whether a sub-postmaster, their staff, or a Post Office employee, on the basis of unreliable data, without anyone knowing? Yeah, and it's terrible. Did you recognise that at the time? No, I suppose, I can, my
as I say, at that particular time, I wasn't thinking about the particular bugs and the errors and the specific impacts that might have had. But absolutely, I mean, having been led to believe that, or being told by Post Office that there were no systematical errors with Horizon, I suppose in some respects gave me some confidence and some comfort that the only errors were incredibly minor and maybe didn't have the impact that I now know had on the postmasters. That's the best I can, and that's my view on that, yeah.
Do you think you should have recognised the risk of this at the time?
Do I think I should have recognised? Absolutely. I mean, I'm sure there's things that, in hindsight, that I may have been able to recognise at the time. At the time, I was, I honestly didn't recognise that issue or those issues were, problematic in that sense. I mean, there's lots of things I would wish I had done or said or done differently. I can't make any sort of excuses for that.
So is that a convenient moment for our first short afternoon break?
Yeah.
So 10 minutes, please, sir, which I think brings us back at just after 1:45.
Well, I make it 38. So shall we
10
give
to.
ourselves 10 to? Yeah.
Yes, sir.
Fine.
Thank you. Hello, sir.
Yeah.
Could we have back on screen, please, the briefing document for the 17th of October meeting? The reference is POL 30-22976. There is just one last section of this briefing I'd like to go to, please, and that is the contingency planning appendices towards the end of the document, starting at page 32. If we can zoom in a little more, please, so that we can see the table on page 32. That's the page above. We can see here what is colour coding, albeit that this is black and white, colour coding of 5 different numbers in the left-hand column for likelihood of Post Office losing a common issue or an implied term being found against the Post Office. And just scrolling down a little, please, so that we can see. And in the right-hand column, there is a 1 to 5 assessment mechanism for impact. So impact on the Post Office if a common issue is decided in favour of the claimants, and that is defined as a significant adverse impact on the business that could threaten existence as a 5, so the top level in the right-hand column. And on the left-hand column on likelihood of 5 is Post Office is very likely to lose the case, the proposed term is very likely to be implied. And scrolling up, please, just to the top introduction section there. This is the bit of the document relating to high likelihood areas, so that's the likelihood column on the left. And beneath that is a table detailing the 4 common issues assessed as having a high likelihood of Post Office losing the issue or having the implied term found against them. Going to page 37. This is the start of the table relating to high impact areas, so those things in the right-hand column. And the introductory section explains that the table details the 3 common issues assessed as having a significant adverse impact on the business if the issue or implied term were to go against the Post Office. So it's saying there were 3 of the issues that would have that impact. Did you read these appendices at the time? They're not part of the main sections, in fairness to you.
I expect I would have read them at the time. I don't recall, to be absolutely straightforward, I don't recall, but I expect I would have.
Seeing the 4 issues which were assessed as being 5s or likely to lose on points, and the 3 in having a high impact were they to be lost, albeit that the likelihood on those was lower. Did that cause you any concern in terms of the risks of the litigation?
I think that I was concerned about all of the risks in relation to litigation. Going back to the point that I made around the fact, I was concerned of the large corporation against the small individual. I was concerned that, I was concerned that actually looking at the information that I'd had, I was being given all these assurances. So I think that, for me, that's definitely in that 17th of October meeting. I felt that the people that were briefing me were relatively confident of their position, but that worries me just because of my sort of concern over the length of time this has been going on and some of the issues, obviously in greater detail. So I think, in general, I was concerned without being able to draw out sort of specific, particular parts or on different particular clauses. I think I had a genuine overall concern, which I think would have been right for any kind of minister to have an overall concern about any litigation that any sort of government subsidiary would be. So I think I had concern, but obviously none on those particular points, if that sort of makes sense.
That document can come down now. At paragraph 34 of your statement, you refer to this concern, the general concern you had, and you say that you remember at this early stage being concerned that Post Office Limited were perhaps overconfident. Can you explain what in particular led you to form the view that they were overconfident?
Well, I think at that particular meeting, I don't remember at any time there was any sort of suggestion or acceptance that there was a potential for losing any kind of litigation. And I suppose in some respects that's what also concerned me, because the objective approach would be obviously to look at the worst case scenario if you were looking at it. But at all these stages, I suppose, these individuals in the room who had obviously spent a lot of time on it and had been working on this for a long period of time gave me reassurance. And I didn't have any evidence or any particular information in order to challenge what was being put in front of me at that particular time. So that's the sort of best way I can articulate it.
Could we go please to paragraph 38 of Ms Tolhurst's statement? That's page 13. And at paragraph 38, you say this: my overwhelming concern at that time, this is at the point of the October 2018 meeting, was that a judgment against Post Office Limited or settlement of the claim would not cause Post Office Limited a financial crisis. I was very focused on keeping Post Office going as a valued service. This is why it was so important to me that I was provided with information on Post Office Limited's financial position so that proper planning could take place. And at 39, you go on to say this: frustratingly, Post Office Limited were not willing or perhaps not able to provide any concrete advice on their liability at the meeting. I was informed by way of a post-meeting note that for any settlement up to around 50 million, the cost could be borne by the company. Above that, they would need to consider whether it could be funded by Post Office Limited or request additional support from HMG. I wanted more information about the arrangements that would be put in place for Post Office Limited's financial liability, and this is something I followed up on the following month. My understanding was that Post Office Limited were not giving me an estimate of its potential liability, because then it would become a known liability disclosable to Post Office Limited's auditors, which may expose it to a risk of trading when potentially insolvent. Whilst I understood that, I would expect Post Office Limited to be able to give me some clear information, even if it was not an official figure.
Yeah.
You also refer at paragraph 126 of your statement to being told in a June 2019 submission that Post Office Limited's auditors had previously had concerns that no figures were included in the accounts on Post Office Limited's potential liability. From whom did you gain the understanding that the reason Post Office Limited was unwilling to be open about the likely quantum in the claims related to the need to declare the risk to the auditor, which could in turn endanger Post Office Limited's position as a going concern?
Well, I believe actually this was discussed in the meeting of the 17th of October, because I do believe asking the question directly, my question to the post office was, what do you think the liability potentially could be to the post office? I wanted to understand what that looked like, and they couldn't give me a figure. And that was a major frustration to me because, and I have to say, one of the things that frustrated me about it was that, I was questioning senior executives of the post office about what the potential liability was. And, okay, I hadn't been a senior director of a large organisation like the post office, but I couldn't understand why nobody could articulate that to me as the minister. And I thought at this point in the process, they would have had a better understanding of what that figure was. But actually, they couldn't even give me an informal figure. So until after that meeting, I had no idea what the potential liability could be.
We do actually have a draft note of that meeting. If we can have that up on screen, it's UKGI 408554. And it's page 2 of that document, towards the bottom. There's a comment halfway down the page, which is the first one from you, so Kelly Tolhurst, brackets KT. And then a little further down, we have KT, additional funding requirements, question mark, would Post Office have enough to cover? Important that department is aware as could be significant potential liability. Is that what you're referring to in terms
Yes.
of what you asked?
Yeah, I mean, this note obviously was a note that I hadn't seen, but that's what I do remember. I do remember that particular conversation at that meeting. So it characterises in some form my my question.
That document can come down now. Did the lack of figures being provided at that stage mean that no account was being taken by the government of the overall value of the claims for the purposes of assessing litigation risk?
Well, at that particular time, my understanding was that Post Office had an ability to make financial transactions up to £50 million. Anything over that would need would be government minister sign-off. Again, I'm not a legal expert. I have no idea what sort of quantums of claims that could potentially be. But when I was told and when I understood that potentially 561 postmasters could potentially have had a claim on the Post Office, I was concerned that that could equate to more than, obviously, the £50 million. So I understood that any negative judgment against the Post Office would have had a massive impact on the finances and the taxpayer, and I was trying to be diligent into trying to push the Post Office into giving me some idea of what potentially that figure could be, and if it would have an impact on the Post Office, the functioning of the Post Office. Because one of the things that it seems, sort of reflecting now, looking back, I was actually really pleased to have the Post Office as part of my portfolio because I thought it was a great business and I thought it was an interesting part of government. So it's something that, obviously, as an individual, I very much wanted to make sure that the Post Office could continue with its function and of public service, obviously separate to the litigation and obviously what I now know.
Could we have on screen, please, UKGI 30s21096? This is a shareholder executive risk register dated the 29th of June 2018. It's a little difficult to see because we need to click into the cells in order to see the text. So when I ask the lady to click in a box, the text will appear in full in the bar across the top.
Oh, okay, yeah.
If we are looking at this first tab, guidance, and cell C6, please, you can see the text here explains that this will be used as a graphical representation of top risks in capitals each team faces and allows for different assets, projects, risks to be compared easily. And in big capital letters towards the end, please only include your top risks. And then if we go to tab 2 of this, please, which relates to the Post Office.
Okay.
So this was a shareholder executive risk register, which had that guidance and had this specific risk register relating to Post Office. Have you ever seen a shareholder executive risk register like this before?
So I don't believe I had until obviously the documents were shared with me, I think, a few days previous.
So these weren't shared with you at the time you were Parliamentary Under Secretary?
I don't believe they were.
If we go to row 38, which is item 11, we can see here possible civil litigation against Post Office Limited. And then in column D, which is risk overview, we have civil litigation and or Court of Appeal processes judged that Post Office Limited has acted inappropriately or illegally, even in the absence of such a finding, ongoing risk that they continue to be perceived to have acted in that way. And then if we look at column E, impact of risk, on that same line, potential for significant compensation claims if civil or criminal courts rule against Post Office Limited. More likely, however, and certainly in the short term, is that this continues to be a significant distraction and cost to the business as they defend their actions. And then column H, we can see that the civil litigation has been given an impact rating of 4 out of 5. Apologies, hang on. A probability rating of 4 out of 5. And then we can see an impact rating there. Forgive me, if we can just scroll up so we can see the column heading. Seems to be current and previous, so referring to 2 different times of that being assessed. Scrolling down, please. So probability at 4 out of 5 and impact at 5 out of 5. Pausing there, was the scale of the risk ever articulated to you in those terms?
I don't believe that was.
If we look at column K, mitigation overview, it states Post Office Limited have external legal advisors employed on the civil litigation, including a KC. They continue to update UKGI through the board where UKGI's NED sits and directly to UKGI's legal counsel under a disclosure protocol that protects legally privileged information. And then at column P, further mitigating actions. UKGI have briefed Minister Andrew Griffiths and will keep ministers, SPADs and Permanent Secretary updated at key points through the new disclosure protocol, with Pol's legal counsel to provide an oral briefing on the 10th of September. So that's the meeting which was adjourned to the 17th of October. Bayes Legal are also up to speed and contributing to any advice to ministers, maintaining a position that government will not comment on an ongoing legal issue. Were you aware that UKGI considered the civil litigation against Post Office Limited to be one of Pol's top-rated risk on its asset register?
No, I can't say that I knew that.
That document can come down now. In terms of your experience of information flow from Post Office Limited, could we have on screen, please, UKGI 3021771? I'm going to page 4 of that document, please. The email towards the bottom of the page. You explain at paragraph 48 of your statement that you met with Tosin Adagan and Tom Cooper of UKGI on the 19th of November 2018. This email is sent the next day on the 20th of November, and it's from Oluwatosin Adagan to Sam White, who was one of your private secretaries. And it says this: "Hi Sam, thanks to the Minister for her time yesterday. Detailed below are the follow-on actions. Both Sams, please let me know if I've missed anything." And that first bullet point, weekly briefings as the litigation case progresses, verbal and written updates UKGI to action. Did you request those briefings?
Yes, I believed I did ask to be briefed. That was sort of normal for me to... I wasn't, I would rather have more information than I needed. So, you're better off having more information. So weekly briefings, I would have requested that at the meeting or as a consequence of the meeting. However, I can't guarantee that I did receive weekly briefings or verbal updates.
Did you request those because, as a matter of your general practice, you liked to have regular updates, or was there a particular concern?
No, I think it was more to do with my general practice. I knew, obviously, it was a big issue. It was something that was that it was important that I did have access to any new information or information as quickly as possible. So it would have been normal for me to have asked for regular updates.
Some emails follow above about how frequently the updates should be sent to your private secretary. And then towards the bottom of the page, I think bottom of the first page, there is an email dated the 23rd of November 2018 from Stephen Clark to Richard Watson and Tom Aldred, which says this: Richard, to see further clarification below from the Minister's office on the Minister's request for trial updates. Will submit once a week. And then that included a roundup of the week's news coverage, and also at the second bullet point, an update from Post Office Limited's legal team on trial developments over the past week. So the second bullet point here was referring to the fact that you wish to have updates from Post Office Limited's legal team in particular. Is that right?
So that would have been something that would have been formulated via the team or with my private office. I don't remember being specific about what I was requesting. I would have just asked for weekly updates and relevant information, not sort of give me information that had no consequence or was irrelevant. So these would have been ideas that would have been put forward by, as I say, I'm unsure of who would have sort of made those three particular requests.
Okay. Then the reply from Richard Watson is above. And it says, Stephen, thanks. I've had no reply from Post Office Limited Legal. I will chase them about it. I have not said to them that the Minister wants the update, partly because I rather feared that would cause the update to be less useful, or perhaps even be met with a refusal to provide one. And then Stephen Clark's email above. Thanks, Richard. I hadn't thought of that risk, but probably very wise based on past dealings. Were you aware that this was what was expected by UKGI, that a request for an update having come from a minister might result in a less useful update or a refusal to provide one?
No, I wasn't. And actually, I would have, and if I had been, I would have been rather annoyed by it, because quite frankly, they would have, I would have, a refusal to give an update to the Minister, I would have thought would have been absolutely outrageous. So if I had known about that at the time, or that there was a concern that that might not be the case, I probably would have raised that directly with them if they were actually refusing to give me updates.
It may follow from your answer, but was this something which you ever experienced directly at any point?
A refusal to give me information? No, I can't say that they refused to give me information. As far as I'm aware, should I say, because actually that was just from my direct contact with the Post Office, for what may or may have been said to UKGI or officials within the team that I'm not aware of. That may have occurred, but with my direct communication, no.
Could we have on screen, please, UKGI 409455? This is an email from Tom Aldred of UKGI to others from UKGI, dated the 5th of April 2019. And the first paragraph of the email says this: on Wednesday, Kelly met with Tim Parker. We also had a good chat with Kelly after Tim had to leave, where I was able to make a few points to her. I also walked over to the meeting with Carl, the new Bayes director, who seemed very nice. Then under litigation and recusal, the second bullet point reads, Kelly complained that she wasn't seeing enough information flow about the trial. We discussed as officials afterwards, and it seems the block is somewhere between her private office and her. Regardless, we should make sure that we are providing updates to her as soon as they are relevant. At this point, in April 2019, what information about the trial were you expecting but not receiving? Can you recall?
I can't say I was. I don't know what I was expecting. I just wanted to have, good information, regular information, and obviously, rather than getting confused on the months again, I know we haven't spoken yet about the recusal, but obviously I was frustrated and angry about that. So I was expecting to get more timely and better information because ultimately, as a minister who had the responsibility to answer the House of Commons or anyone that asked the questions, it was right that the information flow should be there, and but I don't quite know what I was expecting to see because I didn't know what I didn't know, but I just wanted that, if I was getting a regular flow, hopefully there'd be information in there that would be useful to me in my role as a minister.
Can I just ask you in general, so that perhaps we can shortcut some of this? In November 2018, that was when the Common Issues trial started. Are you telling me that during the course of that trial, so that in the weeks effectively of November and December, you felt that you didn't get enough information of how that trial was progressing? That's point one. And then coming to this point in time, which is April 2019, we've now got the judgment in the Common Issues trial. Everybody knows that the Post Office lost. And so we're talking about the information you want to get in the Horizon Issues trial. So with those two staging posts in mind, so to speak, first of all, going back to question number one, did you feel you were properly kept up to date with what was happening in the Common Issues trial?
Thank you, Sir Wyn. I felt that I was getting some information, and at the time I would say that I couldn't, at the time, I couldn't make a judgment on the reliability or the level of information I thought that I was getting. I suppose my big issue was, obviously, after the judgment was made, it absolutely was clear that I wasn't getting the updates or the information that I felt that I needed to know, if that makes sense, if that answers your question.
Well, it answers my question about the Common Issues trial.
Yeah.
And then once you knew that the Post Office had lost that trial, to what extent, if at all, were you demanding greater discipline, if I can put it in that way, in keeping you up to date with what was happening in the Horizon Issues trial? We leave recusal as a separate topic for Ms. Price to deal with. But so far as the Horizon Issues trial is concerned, were you kept up to date in a more disciplined fashion? I can't think of putting it in any other way during the course of that trial.
I was given more information from, obviously, we had the policy team within Bays and my private office, and we were all sort of trying to keep abreast of what was happening. But I don't think that I was kept updated in a more disciplined way. Hence, whilst I was, I felt like I was continuously sort of asking for more info, more detail. Because clearly, the judgment, there were issues. that there were clearly issues with what the Post Office was saying and what was happening based on that judgment. So, you know, I didn't want to be blindsided as well, if that makes sense. So my determination to keep asking for information, asking for more detail, meant that, you know, in my view, I thought that I would know what's coming, if that makes sense.
All right. And then one last question before I hand back to Ms. Price. When you were saying more info, were you directing your requests to officials in UKGI or officials in the department, or to both?
To both.
Fine. All right, fine. Sorry, Ms. Price.
Not at all, sir. Ms. Tolhurst, and that document can come down now. A number of times in your statement, you touch on the relationship and engagement you had with UKGI specifically, to follow up on the point made by the chair as to who you were encountering difficulties with. And if we could have on screen, please, paragraph 88 of Ms. Tolhurst's statement. That's page 31. And you deal here with April 2019, the information, your private office saying that Tom Cooper wanted to meet you to update you on the litigation, and you saying you'd rather the updates were formalised. And then just going over the page, please. At 89, you say, I suspected by this time that Tom Cooper had gone native. My feeling was that he had lost his independence from Post Office Limited and was not providing effective challenge or scrutiny. What did you mean when you said Mr. Cooper had gone native?
Well, I meant that his objectivity had been lost, I suppose, in regards to, you know, whether that's a fair characterisation or not of his approach. But that was my feeling at the time. That's all I can sort of say. And I think that had been borne out. Well, as I think I've said in my statement, actually, that you know, and I know we want to come on to it. So, but what happened around that recusal obviously gave me cause for concern. And the reason I made a fuss about not wanting to meet the people informally is that, you know, this was very, you know, I wasn't ignorant enough to know, not to know how serious the whole litigation was. And, you know, I sort of, because I had sort of become frustrated with the information flow, I didn't want informal information. I wanted information that was recorded and on the record, hence why I didn't want to have a random communication as I characterised it.
In relation to Mr. Cooper's request for a meeting, Mr. Cooper's evidence to the inquiry was that he would have benefited from a lot more in-person contact with the department, but in particular you. And his evidence was that the department had received briefings, but no questions came back. How would you respond to that?
Well, so even as a junior minister, I had a wide portfolio, and I had lots of responsibilities. At this particular time, we had a number of other challenges within my portfolio, not just the Horizon litigation. Absolutely, I want to meet with all stakeholders. But as one individual, there is a limit on some of the personal contact that you can have with those stakeholders. However, he had open and unfettered access to the base team. He also had the ability to speak with the permanent secretary, and any kind of severe concerns in my view, shouldn't have been just purely reliant on having a face-to-face meeting with me. If he had had those serious concerns, or he had something that was important to the department, you know, I would have imagined and I would have hoped that anyone working in that environment would have raised it with a number of other people rather than only speaking to me, unless it had, you know, it was something like a whistle blowing or something like that. So I would say that, yeah, absolutely. As a minister, I was always willing to meet with whoever I could within reason, particularly where it affected my portfolio. But, you know, I recognise as well it wasn't possible with just the other pressures at that particular time to meet with, you know, I wouldn't have been able to meet with him on a weekly basis. But that's a rather long answer, but I just wanted to give you the context of that. So I would say that's slightly unfair to suggest that because he didn't have as many face-to-face meetings with me, that there was no sort of feedback from my office, so to speak.
Coming then to your reaction to the Common Issues judgment and the recusal application, can we have on screen, please, paragraph 58 of the statement? That's page 21. And this is you being made aware of the judgment, and at 59, your immediate reaction was one of embarrassment. You were appalled that the judge had found Post Office Limited to have behaved so reprehensibly, and you felt utter shame on behalf of Post Office Limited in respect of what the SPMs had been through. You say you had a call the next day with UKGI about the judgment, and then going over the page, please, a call with Tim Parker, Alistair Cameron and Jane McLeod. And you set out some of the speaking points for that call, which reflect your immediate concerns. And then over the page, please, at the next paragraph, you describe the handing down of the Common Issues judge as a light bulb moment for you. And you also say that your concern was what was going to change now the litigation, in terms of how the litigation was approached. A Dear Colleagues letter was sent to all members of the House of Commons after this judgment, wasn't it?
Yes.
And you explain at paragraphs 65 to 68 that you had originally recommended that some wording be included, which was subject to some amendments after comment from UKGI, but this wording was removed after input from Post Office Limited. Is that right?
Yes.
And the wording you originally proposed is set out at paragraph 66. And that wording was that the judgment represents a significant step forward, delivering justice for those postmasters who have been wronged. You provide your reflections on this at paragraph 69 over the page, please. And you say, looking back now, this is probably one of the areas where I should have pushed back and insisted on the original wording. Why do you consider that the original wording should have been kept?
Because I believe that actually it was the true characterisation of how, I felt as the minister at the time. But, and looking back, I wish I had pushed harder on that wording.
Coming then to the recusal decision, you say you were at this stage, the drafting on the Dear Colleagues letter stage, unaware of any suggestion that Post Office Limited might seek for the judge to recuse himself, and that you became so aware on the 19th of March 2019, when UKGI informed your office of this. Is that right?
Yes.
You say at paragraph 71 that your view and your official's view was that the application should not be made, and that you had very grave concerns about it. And 3 lines down, you say this: I believe that the Permanent Secretary, Alex Chisholm, took this forward and tried to discourage Post Office Limited from making the application. At no time was anyone at POL given reassurance that government would be happy with Pol making this application, and you say quite the contrary. By quite the contrary, is it your evidence that you told Post Office Limited not to make the recusal application or not?
So I did not have any discussions with Post Office Limited directly about the recusal. But as far as I can remember, I don't remember having that direct conversation with them. However, what I do remember is that, you know, my reaction and that of the others, you know, other people within the department, that this was something that, you know, was not something that I wouldn't support it, and I thought it was rather, you know, madness really. But that I don't believe was directly articulated directly to Post Office Limited.
You deal at paragraph 73 with what you were told about whether government could or should be involved in the decision. And you say it was apparently not, however, within the department's gift to stop Post Office Limited from making the application. If it had been within your gift, would you have stopped the application despite the legal advice to the contrary?
Well, I believe I would have, because it's easy to say. It's easy for me to say that in hindsight, with what we know now. But my view as a complete layperson in this area, my feeling at the time was, you've had a judge that's made this incredibly damning position about the post office. So I was very surprised how that the Post Office first thought was to try and then recuse that judge. You know, as a layperson, I thought it was something that was madness. Even depending on what that legal advice had been, and actually, you know, I think that we wanted to make sure that this came to a resolution and that it was moved forward. And, you know, I was definitely concerned that anything like this could delay any further, the progression of the case, to draw a line under it for the individuals involved.
Could we have on screen, please, WBON 301756? This is an email from Jane MacLeod to Tom Beezer and Andrew Parsons, copied to others, dated the 16th of March 2019. And it says, "Many thanks. I have a call at 2:15 with our chairman, Al Cameron, and our minister, Kelly Tolhurst, and others. Although I don't believe recusal will be part of the discussion, I have been advised by the UKGIGC that government will not express an opinion on recusal, as they will not want the executive to be seen to be criticising the judiciary." Was recusal discussed on the call on the 16th of March? That was 3 days prior to the date you give in your statement for saying you were aware of it.
I genuinely, I can't remember the exact details of the call.
The suggestion that the reason government would not opine on the recusal application was said that it did not want the executive to be seen as criticising the judiciary. Did you personally receive advice to that effect?
So I don't remember I don't remember receiving advice to that effect. And actually, that's not how I was thinking. So my objection to the recusal was not worried about whether or not the government would be seen to be criticising the judiciary. You know, from my layperson's point of view, I thought that it was just absolutely the wrong thing for the Post Office to be doing, just because they had had a judge who had made a scathing judgment against them. So therefore, I couldn't understand how that would help in any way the Post Office Post Office's case going forward with any future judgment. So whilst that may have been the department's view, which I don't disagree with, I'm just saying that my thoughts at the time were very much in that place as opposed to particularly concerned with what the judiciary may or may not have thought.
Having seen the documents which have been sent to you more recently,
Yeah.
are you aware that Bayes Legal and the Permanent Secretary had taken the view that the department should not involve itself directly in the recusal decision?
Yes.
We needn't turn it up unless you'd like to see it, but there was an advice from Bayes Legal to Mr. Cooper that he should not take part in the decision on recusal on the 15th of March 2019. Were you aware of that at the time?
I don't think I was. No, I wasn't aware that that the advice he had been given was to not take part in that discussion. As far as I think I am correct in saying. However, I think this represents one of the concerns and one of the issues for me, because having the shareholder representative on the board not taking part in a significant decision that had the impact on the organisation of which we were the shareholder, and of a position that you know I didn't agree with, I suppose was a concern, is a concern and is a concern. How were we able to, whether the advice was correct or not, I'm disappointed and I disagree with it, because I believe that if you are a shareholder, if you are a board member, unless you have a very clear conflict, you should be taking part of those decisions, it's a frustration to me.
Could we have on screen, please, UKGI 409321? Going to page 2 of that document, please, about halfway down. There is an email from your private secretary, or one of them, it seems, to Tom Cooper, which refers to brief discussion of this with Kelly over the phone, and as expected, she has concerns. And this relates to the recusal application being considered. Immediately, she said she would raise with Secretary of State. This is 19th of March at 17:15. I have flagged this to his office and I believe she has already contacted him. She has agreed that they shouldn't do anything until after the decision has been made at the board meeting called tomorrow, and that's the Post Office Limited board meeting to decide whether the application should be made. Is that right?
I think so.
And it is likely she will want another call with Tim Parker and Al Cameron after this to ask them to explain their reasoning behind their change of mind. So it would appear from this that there was a plan for you to have a discussion with the Secretary of State, but you had decided not to contact Post Office Limited to intervene in the decision before it was made. Is that right?
I don't believe I made a decision not to intervene and speak with the Post Office to. I don't believe that correctly articulated what that note meant at the time, because I was very clear on my position. Hence, whilst I had spoken to Secretary of State, it may have been. I can't. I wouldn't have seen this message. I don't remember refusing or not agreeing to speak with Post Office Limited on this issue.
Well, did you make any attempt to speak to Post Office Limited on this issue before the board meeting decision?
So my belief was that I understand, if I remember correctly, that Alex Chisholm, who was the then permanent secretary, was going to speak with the board, or not necessarily speak with the board, but it was left with him. But I think, you know, very clear that I definitely didn't try and avoid or refuse to speak to Post Office Limited on this, because if I had felt that I had had an opportunity to influence it, I would have taken it.
That document can come down now. You received a submission on the 11th of June 2019 about the Post Office litigation. Can we have that on screen, please? It's BEIS 5075. If it helps, you address this submission at paragraphs 124 to 128 of your statement, if you want to refer to them. So this submission, you are one of the recipients, and under summary, at the industry meeting on the 4th of June, you, Secretary of State, so being the top recipient, asked for advice on how the ongoing Post Office Limited litigation could be brought to a swift and satisfactory conclusion, ensuring postmasters who had been treated unfairly were appropriately compensated. Does that reflect your wishes at the time as well?
Yeah, absolutely.
And the potential options which were available to you are set out on page 4 of this document. Can we go to that, please? And it refers you to a table at Annex A with a range of options, and they were said to range from challenging the existing board, Post Office Limited board, to change their litigation strategy, to more fundamental changes such as replacing the Post Office Limited board or BEIS assuming control of the litigation strategy. And then the risks are explained at 18 of more vigorous action. And those included forcing further changes to the leadership team, risk disrupting the progress Pol would have made in other areas of operation of the business. Making public statements or directing Pol to take certain action could weaken their negotiating position in relation to settlement and make it harder to stick to the existing BEIS line that this was an operational matter for Pol. And then the recommendation was that you choose from options 1 to 7. And options 1 to 7 were the less fundamental changes of the options, is that right?
Correct, yeah.
And they're the ones, I won't go to them for the sake of time, but the ones that you set out at paragraph 125 of your statement. Looking at the points made in paragraph 18, was there pressure to maintain Pol's financial success as a priority over the concerns and interests of sub-postmasters?
I don't believe so. That was definitely not something that was my approach. I would say it was never about protecting the post office over sub-postmasters. It was about making sure that, you know, as a people, you know, as a taxpayer responsible body, we had confidence in the leadership and the processes, and that the right decisions were being taken.
In respect of the line referred to here, that the litigation is an operational matter for Post Office Limited, did you agree with that?
I did agree with it, because at that particular time, because obviously there was an executive team running the post office, and they were responsible for the operations and delivery of the post office as an organisation. And, you know, as far as I was aware, none of the officials within BEIS notwithstanding whatever the officials in UKGI had been informed of, that it was something that they were leading on, and that it was their responsibility to resolve as well.
Wasn't this a classic example of an operational or contractual matter which was concerning ministers at a policy level, such that simply leaving matters to Post Office Limited on the basis they were operational was not a defensible position?
I think in, looking at it from hindsight, we could say that absolutely, actually, I think, we can go on. I'm sure you'll pick up with me about the, the future and, potentially what is wrong. But I think that at the time, all I can talk about is at the time and when I was involved, and I did think it was an operational matter. Yes, I was concerned in relation to policy and how that would affect policy, how that would affect future decision making. But I didn't believe that we could take operational responsibility for it, because obviously we weren't appraised, or we weren't, or I definitely wasn't directing the legal advice, or I don't even know what the questions were asked of the legal representatives when this legal advice was given to the Post Office. So I think that absolutely it's what we know now, and absolutely it was it's a mistake that it shouldn't have been. Government should have had better oversight of what was going on at that time.
Why ultimately did you choose not to make radical changes to the leadership of the board, so the harder options that were in the submission?
So I thought about this obviously since writing the statement, and I don't remember exactly, other than I don't remember exactly why I went from being very determined in my views to move on the chairman and change the board, that we didn't end up doing that. Other than that, I would imagine that there was no appetite for that within the department, or the advice that I was being given by the permanent secretary and the team at the time. It would have been seen as a very sort of I think I described it in my statement as a nuclear option. And this was my first ministerial role, I was really keen to make sure that I acted appropriately, and obviously I did take note of advice and that I was given. However, I will caveat that in the sense that whilst I take note of the advice, if I thought that I had an opportunity to do it, I would have taken it. So but I can't explain exactly why I didn't go for that particular option.
I'd like to come finally to your reflections, and starting with paragraph 194 on page 70 of the statement, please.
Before you do that, Ms. Price, could I just check with you? Are we having a sort of second break, or are we going to the end now?
So I think we are going to have another short break, after which there'll be some questions from core participants. I will only be a couple of minutes further with my questions, at which point I was going to suggest at 5:02 we take the break to 5 past.
Fine, okay.
So page 70 of the statement, please. In the interests of time, I won't read out all of paragraph 194, but that is the paragraph that essentially deals with what you think was inadequate information being provided to you. And then on 71, we have 198 and 199, where you make some observations in respect of the governance structure in this instance. And in sum, is it correct that your position is that first, the government was not given sufficient information to act appropriately, and second, the structures in place tied the government's hands as it had no directing power? Is that a fair summary?
Yes, it is.
Is it right, though, that in terms of access to information, the government had a representative on the Post Office Limited board, and you were in a different position in terms of knowledge of matters after the Common Issues judgment as compared with before?
Yeah.
The government also had that nuclear option of removing the chair in extremis. Was there any conversation about the responsibility of government and collective cabinet responsibility in the context of litigation being defended in a way which it appears you believed was increasingly indefensible?
I can't speak for, I don't know whether that was discussed, and I definitely, I genuinely can't answer the question about the Cabinet's involvement or whether that was discussed at that particular point. I think for if I could just, I remain concerned and, about, at the time, I would have loved to have had powers of direction of the Post Office, actually, because, if I am furnished, I was, more than happy to take decisions. So I think that, fundamentally, the structure of the Post Office and the way it's been set up, and also even that connection between UKGI and the department. So, for example, the UKGI shareholder representative wasn't a member of the department, so it wasn't someone that was directly answerable to me, for example, or the Secretary of State. I think I was operating within the system that was there, and whilst I accept that, the structure of the organisation, I had to work within those boundaries. Yes, it was a frustration, and, that's something that I believe that maybe if it hadn't have been set up in that way, we would have, I would like to think that this may have been resolved early on, because ministers would have had that ability to direct and take further decision. I mean, I think even, sorry to sort of labour the point, but just going back to even to the point where the minister had to sign a protocol for information sharing. I mean, even me coming in as a layperson, I thought, well, hang on a second, if I am the minister responsible, why do I have to sign a document to say that I'm not going to share, so that I can be given that information, when actually we are the shareholder, we own the organisation. So I think that, I would like, I'm also very keen to see the outcomes of the inquiry in relation to the recommendations that are made, because obviously it's something that, has caused me, concern and a lot of reflection since the process, since I was a minister in the department.
So those are all my questions for Ms Tolhurst. It is between 5 to and 4 o'clock. But I wonder if we could come back between 5 past and 10 past if we're going to get through the questions.
Yeah, by all means. I'm prepared to stretch 4:30 a little, but I just so that everybody knows, my absolute limit today is 4:45. So either questions have to be asked within that time frame, or some other arrangement has to be made. All right.
Thank you, sir. Understood. Good afternoon, sir.
Good afternoon.
We have questions from Mr Steen and Ms Patrick. I'm told there will be 12 minutes each.
The precision grows. All right.
Sorry, grateful. I'll start my 12 minutes now. Ms Tolhurst, my name is Sam Steen. I appear on behalf of a very large group of sub-postmasters, partners, mistresses, and their and employees in branch offices. You said towards the end of your evidence, when you were being asked questions by Ms. Price, that you are looking forward and you're very keen to see the outcomes of the inquiry in relation to the recommendations that are made. Okay? Mm-hmm. Now, if you like, the lens through which I'm going to ask you a number of questions is that one.
Okay.
That recommendations, how can we improve? What is going to be better in terms of government, the way government operates? All right?
Okay, thank you.
Now, to help with that, and as a starting point, can I take you, please, to paragraph 35 of your statement? Go to that, please. And you'll see there, paragraph 35, that's page 12, Ms. Tolhurst's statement, that you're referring there to a briefing authorised by Pol for 17th of October meeting. The briefing was extensive, although Section 2 setting out the background to litigation was relatively short. You go on to say, I did not understand this to be a meeting about litigation strategy or the merits of the claim. So I'm going to take you now to that briefing. Okay. And if we can go to that, that briefing is to be found at POL 000-22976. If we look at page 1 and have that on the screen, that would help. So this briefing paper, as you'll see, and you had this in your pack, it's a meeting on the 17th of October 2018, and it has a reference to yourself, Mr. Tolhurst, Parliamentary Under-Secretary for the Department of Biz, etc. Okay? So you're joined and taken on this ministerial post, I think, in July of 2018, so you'd had some time to get familiar with the role, but not very much time. All right? So the particular paragraphs I'd like to ask you questions about at page 10, paragraph 3.3, please. Three point three, please. So we drop down just slightly from there. Thank you. Right. So 3.3, the most important common issues concern the liability of agents for losses. And then it goes on to say this. The claimants argue that Post Office needs to show that a postmaster's actions have caused Post Office to suffer a net economic detriment, not just that the branch's accounts ostensibly show a shortfall. Post Office's position is that if a shortfall is shown in the branch's accounts, then, absent any cogent evidence to the contrary, the postmaster is liable for that shortfall, given that they are responsible for conducting the transactions recorded in those accounts, and for the Post Office cash and other assets used. Paragraph 3.6, please. So over the page, page 11. Post Office's external counsel believe that Post Office has the stronger arguments on most of the common issues. Okay, so you're being given a pointer here within the briefing document to what are strengths and weaknesses, all right? However, they also caution that the areas likely to be most problematic for Post Office are the clauses dealing with suspending and terminating postmaster contracts, including length of notice, withholding remuneration during the periods of suspension, and imposing liability for branch losses, okay? So you're being given a steer as to areas of real concern for the litigation. And one of the steers that you're getting, and an area of real weakness that's being identified, is regarding this question of how shortfalls are accounted for within branches. So we add up the pieces we've got so far. You've been in post for a few months. One of the jobs that you had to do is essentially look after areas that relating to the Post Office, yes? Mm-hmm. You need to say yes or no.
Yeah.
Thank you very much. You understood that the Horizon system was essentially the working operating system for branches, and that it was an accounting system run by the post office, yes?
Yes.
And you've lived, I think you've lived and worked in Kent and we were an MP in Kent. You're as familiar as we all are with small branches of post offices up and down the country.
Yes.
And you've said already in your evidence that you were aware that these branches were small businesses as against a much larger corporation. Okay. So what we've got here, it seems, in the briefing, do you accept this, is you're being warned, look, there's a real issue about this question of how we impose liability on those small businesses. Do you agree that that's what it says?
Well, I agree with that's what it says, because obviously that was the nature of the litigation and the dispute. And it was obviously an update of the litigation, hence the first sort of big brief I'd been given since taking on the role.
One of the things about this brief, and if we flick through it, we can see that it's something like 50 pages. It's quite dense stuff, okay? So we can see that by being given this amount of material, without it necessarily identifying, look, it's told us this is the hot topic. If we lose this, this could be curtains for the post office, because the very identification of who's responsible for paying these shortfalls is pretty much an essential foundation of the litigation. Now, that doesn't seem to have happened. It doesn't seem to have got onto your operational radar as being, look at this, watch out for this problem. Do you agree?
So, yeah, I would agree. So, for example, I mean, one of the ways I work anyway, and I had it a number of times in that portfolio, I had to get to grips with very large documents or points within government that I had no experience of before. So I'm absolutely fine with reading documents, taking it in. Obviously, there may or may not be some questions that I may or may not arrive out of reading what's put in front of me. But you're quite right. So I don't remember or recall anyone, when I first looked at this brief, saying this is going to be a problem, this is something that that the post office, will have such a bad judgment on. And the reason I say that is because obviously I had this going into that meeting and then having those assurances that there was confidence from the post office that they were right. And obviously, whilst I'm not a lawyer, I don't have any legal experience, and I wouldn't, and I'm sure the civil servants wouldn't have liked it for a minister to have, they would always caution against going against sort of legal advice.
But here, Mr. Tolhurst, the legal advice actually is, look, we may well lose on these issues. So here's an area whereby the owner of the post office could have said, hang on, if we could, what does it mean if we lose on these issues? How bad is that?
Yeah.
Now, you say in your statement, I don't want to go to it because of time limitations, paragraph 57, it was probably, this is March 2019, probably at this time I was first told of the core issues in the Horizon Issues trial. Well, actually, when we go back to this briefing, you are being told about these core issues quite a lot earlier than that. Now, where has this gone wrong? Should somebody, and if so, who, said to you, look, if we lose this, this really is significant for the entirety of the litigation, the company that we own. Who should have pointed it out to you, do you think?
Well, actually, sorry, so I think that it was, so actually there's not one person that is, it's a failure of the whole system, because actually I think, as I said earlier in the evidence on the answer to...
I said who. You may want to say role or position. No, my fault.
So in answer to Emma Price's questioning, and I said actually that... severe. I shouldn't have been the first or the last person to, or could have been. I shouldn't have been the only person to have had that message. So that, if there was a severe issue, I would have expected it to come through the shareholder, the government shareholder representative on the board, because ultimately that's their their role, but that should have been something that had been discussed widely. It would have been something that you would have expected UKGI to be over, our permanent secretary to be over. It should have been, you shouldn't have had a junior minister chasing around or sort of, working out what information or what not to believe. And I think that's the fundamental issue.
Okay, can I tackle
Sorry,
that? No, that's fine. Can I tackle that? Paragraph 78 of your statement.
Yeah.
Sir, page 28.
78, yes.
So paragraph 78, page 28, you're talking there at the beginning of that paragraph about the arm's length model. You're talking there about, I think if I recall correctly, about the recusal application and legal advice, which I will, if I have time, I'll just quickly go to in a moment. But this point about junior minister point that you've just gone to, you say this at paragraph 78. The situation at that time, arm's length, senior counsel legal advice and so on. This did not feel enough for me as a first-time junior minister to go against the advice. In my mind also was that in taking that sort of action, then you go on to talk about other issues that you're saying are in your mind. But it's not just in recent history that there's been a churn of ministers. There is a frequency of change of ministers across our system.
Yep.
And indeed, you have occupied various posts, quite short periods of time. So you're quite a good person to ask about this. It's frankly quite difficult to get a sense of governance from ministers that are constantly changing, who are constantly having to be briefed, worked up in terms of knowledge, and then start making decisions. Because you end up in challenges like this. I've been told by senior legal people, X or Y. What do we do to change that? How do we make sure that somebody actually gets a grip on these things?
Well, I think specifically around the post office, because I do agree with your point, in regards to churn and ministers getting up to speed, being given that information in order to make proper decisions. But I think where the post office is concerned is slightly different, because and this is where, and it goes, I think I've said it in my statement, but excuse me, I can't remember the paragraph without looking it up. But And my only sadness is that Post Office Limited wasn't what I would call a true arm's length body of government, where actually, as the junior minister, I would have had powers of direction and absolutely the position to be able to ask and demand information or make a judgment. And for me, even though it was my first time ministerial appointment, I've spent my whole life taking, living with the consequences of the decisions that I make in my work life. So if I had been in a position where I could make decisions, I would have, it's a phrase I've used, I live or die by my sword. And if I made the wrong decision, I'll take responsibility for that. If I made the right decision, all very good. And that's one of the things that and for me, this is the problem, the fact that it was a limited company, not a true arm's length body of the government. And therefore, I personally, if I can say, I hope that one of the outcomes of this inquiry is actually the post office structure is completely changed.
Let me briefly, and I will finish on this, legal advice, paragraph 73 of your statement.
Sorry. Yep.
Now, paragraph 73, it's an example of legal advice that's being given, but you refer generally in your statement, as you have in your evidence, to strong legal advice that you've been given. Effectively strong legal advice to stay out of it, to not interfere with this particular body. Now, for the people that I represent, that feels mad, because there you are, you own, essentially, as the government, you own the post office. Now, the legal advice that you're being given, if you look at what you have there at paragraph 73, which is reasonably good by way of a reference to the type of legal advice, it's not legal advice that is saying that there's legislation that says you've got to keep out of this. It's not cases that say you've got to keep out of it. This is more kind of, we think it might not be a bad idea if government sort of keeps away from it because we don't want to get burnt type legal advice. Yeah. This is barely legal advice if it's a legal advice at all. Why did you feel that you had to follow stuff that isn't actually rooted in law?
Well, because as as someone who is not an expert, and particularly in regards to legal matters, and I can't profess to be so, when you are given, if you are given advice from trusted, experienced, qualified, or people that you perceive to be qualified, I had nothing to, at that particular time, or especially in short time, you've then got to rely on being able to have other advice in order to challenge that. And actually, and one of the challenges, going back to your earlier question around, the response, I'm not making excuses, please don't think that that's the case, but, there is so much going on, there are so many demands on your time, you only have a certain amount of bandwidth, so you do have to rely or put some trust in some of the information that you're given by your advisors. And that's not a get out, I'm not trying to negate any responsibility for not challenging, because absolutely that's the role of a minister to challenge. Others will judge whether I was right or wrong. I just tried to act in the best that I could at that time.
Do you agree that ministers in the future need to look at the question, which is this actual legal advice? Is this about the law saying something that can or can't be done because that's a legal principle, or is this other types of advice which isn't necessarily from anything other than coming from lawyers?
So I agree.
No further questions. Thank you, Mr. Tolhurst.
All right, thank you. Just one follow-up on that before Ms. Patrick. It seems to me that your core complaint, when you talk about what frustrated you, was your inability, in effect, to direct the post office what to do in certain circumstances. So I take it you want me to look at the powers of direction, if any, which currently exist, and whether they should be greater.
Thank you, Sir Wynne. Yes, I would...
I've got the point, that's fine. Yeah. Ms. Patrick.
Thank you, sir. Ms. Tolhurst, my name's Angela Patrick. I asked questions for a number of sub-postmasters who were convicted but have since had their convictions overturned. You can see Mrs Hamilton to my left and Miss Hall and Mrs Henderson to my right. Mm-hmm. I have two matters, and I think I'll only take you to one document if I need to. And the first, I think we can take quite quickly. Ms Price has asked you questions about your concern that you had around the time of the recusal, so spring 2019, that Mr Cooper had gone native, and that you were having problems getting information through UKGI. She's also asked you a general question about cabinet collective responsibility. Mm-hmm. Did you raise your concerns about Mr Cooper having gone native, or your concerns about blockages of information coming through UKGI with any more senior ministerial colleagues, your Secretary of State or anybody at the Treasury?
So yes, and absolutely, that's why we ended up with the paper, which gave us a number of options and on how potentially we could move forward. One of the things that I think I referred to in my statement is that, I was concerned about what was happening at the board for the shareholder representative, and I was very annoyed about the recusal. My initial reaction was, I know we didn't end up in that place, but my initial reaction was I wanted to change the board, and I wanted advice on how I could remove the chair. If I look back, if I had taken that decision or enforced or got that decision made, what would have, would that have affected things? I don't know, because we don't know in hindsight. I do believe I raised concerns, and hence whilst I also mentioned in my statement that I didn't want informal meetings, I wanted it on record, the information that I was being given, because it wasn't until...
Can I stop you there? We've got your witness statement. I just want to say, you did escalate it. Yeah. Now, we're going to hear from other ministers. That kind of communication, where you have concerns about what your briefings are happening, how they are, whether the role's being performed properly. That's something that any minister could do. They can share concerns with other ministerial colleagues, they can raise it, they can escalate it if they've got particular concerns at any time. That's fair.
Yeah.
Secondly, I just want to return, again in that general sense, to what you say about the powers and responsibilities of government in respect of Paul. And I won't take you to a document I was going to take you to, just to save time. It's a document called, I'll give the reference, Paul 20259978. And it'll have been very familiar to you, Minister. It's a long list of PQs with your name on, where you say most of them have answers which start with Paul is wholly owned, but Paul is an independent commercial business. That's a line that would have been very familiar to you from the start of your role. And it's reflected in the evidence you've given to the inquiry today about your concerns about the arm's length role of the Post Office and the limitations and the responsibilities and the ability of government to direct. And again, you've said about operational issues with Miss Price, and you've addressed that with Mr. Steen. I just want to go back to taking hindsight out of the picture, what you and other ministers would have known at the time you were in post. You'd have known that the Post Office was wholly publicly owned.
Correct.
And you, of course, have addressed the fact that the government would have had that nuclear option that all shareholders have. They could have got rid of the chair and they could have got rid of the board at any time. You're nodding. I think you have to say yes.
Oh, yeah,
or
sorry,
no.
sorry. Apologies. Yeah. Yes.
And you've said repeatedly, like others have, that you would have been deeply conscious about the important role the Post Office played in the community. You would have known that the Post Office was a business with public commitments that had to be discharged.
Yes.
Commitments that the government was very conscious of. Now, you knew the government had passed the 2011 Act and was working with a goal towards mutualisation for the Post Office. You would have known that in your role, wouldn't you?
Yes.
Yeah. Now, the inquiry's seen repeated correspondence appointing repeated Post Office chairs where ministers write to those chairs and set the goals they see for the business. You would have known as Minister that government was essentially setting strategic goals for the business that they were essentially working through the chair to achieve.
Yes.
And you knew that the Post Office continued to rely on a really important public subsidy.
Yes.
And one of the goals was to reduce that public subsidy.
Yes.
Yeah. This was no ordinary independent commercial business, was it?
No.
No. So was repeating that line, as government often did, including in PQs, really just a convenient way to avoid the true picture? That the government didn't want to face up to the fact that the Post Office was a state-owned body which had, or at least potentially may have, unlawfully prosecuted hundreds of innocent men and women for years.
So my response would be that I don't believe that, I definitely wasn't using it as a convenient excuse not to get involved. I fundamentally believed that I was unable to. And hence whilst I've made the comment about what I believe that really, if the government are ever in a position where they own it doesn't work. Government can't be a shareholder of an organisation without having fully operational responsibility as far as I'm concerned.
Can I stop you there?
Sorry.
I'm very conscious about time.
Yeah, sorry.
And I just want to go back to that notion of the nuclear option.
Yeah.
That the only option the government had was that nuclear option to get rid of the chair. That nuclear option, whether it's owned by the government or any other majority shareholder, that nuclear option gives you leverage, doesn't it?
Yeah.
And you had serious concerns about the direction of the litigation, you had serious concerns about Tom Cooper and about UKGI, and you say you did something about it. Now, we'll look at that. But if you or any other minister really wanted to do something about what the Post Office was doing, whether in the litigation or in its other conduct, you really did have options short of the nuclear, didn't you?
Yes, I mean it's highlighted. I've absolutely been clear about that, and if I had, you know, I said earlier on in evidence that, you know, I don't know why I can't. You know, I know there wasn't an appetite for it. However, actually, I was someone who, you know, I would have fronted out, even if it had been the wrong decision, I would have fronted that out. And, you know, that's one of the. I don't know what would have happened if I had have taken that decision, and if I hadn't have sort of been discouraged not to. I don't know if it would have had an impact for the postmasters and subsequent, subsequent operations. And that's something that, you know, I can't answer. I can only explain what I was thinking and where I was at the time. But you're right. But I mean, I can only speak for myself. I can't speak for other ministers. You know, for me, it was definitely it wasn't an excuse not to get involved, because if I felt that I had justification and evidence to back up a decision, I would have taken it.
And just to bring it back to the very simple question, you focused in what you said to Mr. Steven, to the chair, and in your witness statement about government being limited to that nuclear option.
Yeah.
It wasn't the only option government had, was it? There was leverage.
Well, I think I've sort of explained that, you know, it was leverage, you know, I asked questions, but
Indeed.
It wasn't enough.
Thank you. That's all the questions I have, Ms. Tolhurst.
Ms. Tolhurst, just so that I'm clear about this, the so-called nuclear option, was that something which you personally could have done if you'd thought that to be the appropriate course of action, or was that for the Secretary of State?
Well, I think it would have been under a direction of the Secretary of State. So when
So ultimately, he or she would have had to agree with that option.
Yeah, absolutely, and they were the options that were presented to us. I mean, it's my characterisation of nuclear option.
No, I follow that. I just used the phrase to identify the process.
Yes, yeah, it was.
All right. Thank you very much. Is that it, Ms. Price?
It is, sir.
Well, thank you, Ms. Tolhurst, for making a very detailed witness statement and for answering a good many questions this afternoon. I'm very grateful to you on behalf of the inquiry.
Thank you.
So we'll resume again at 9:45, I take it, tomorrow with Mr. McFadden. Is that right?
That's right, sir.
All right, fine.
Thank you.